today's webinar, Mr. John Good. John, please take it away.
Good afternoon. Thank you, Rick. And thank you, Manufacturing Works, Ann, and all your affiliated members for inviting us back. Is my video going? I think so. Next slide, Ann. What we're going to talk about handling the restart, some of the questions that we're seeing from the consequences of the stay-at-home orders and when employers are starting to open back up. What are some of the tricky employment issues that employers are seeing? And to sum it up, this first part of the presentation, we'll be talking about, some employees who are eager to get back to work. Some employees are really scared to come back to work, and they're scared to come back for a variety of reasons. Some of the employees were sick and are recovering themselves. Some are medically fragile. They have some underlying conditions, or they have family members who are medically fragile. And they're afraid to go back out into society, come to work, and they're afraid of being exposed to the COVID and bringing that back home to their family members or compromising their systems. And then there are some people who are just uncomfortable coming back to work because they don't want to contract it, but that they're not sick and they're not fragile. They're just scared to come to work. I'm going to talk about these people, some of the current lawsuits that we're seeing that have been filed in the past 2 months. And we'll talk about some EEOC considerations and some OSHA updates. My fellow partners, Warren Rossman and Jack Klesnick, will also be, speaking after me. Next slide. We are seeing, like I said, 3 situations: the person who is sick and symptomatic, who is not, and B, the people who are not sick but medically fragile due to underlying conditions. This could be rheumatoid arthritis, which compromises the immune system. They could have some other autoimmune disorder. They could have diabetes. But this second category in B, these people aren't disabled from work, but they do have some fragile conditions that really scare them, and they're kind of hesitant to come back to work. This third group is people, that are not sick, they are not compromised or fragile, they're just hesitant to come back to work. Next slide. The easy situation is the person who has been sick or symptomatic. Christine has a fever of 104, dry cough, visited her mom at a nursing home who has since been diagnosed with COVID-19. So a lot of us have family members, or we know people that have come down with either been diagnosed with COVID or come down with a really bad flu in December, January, February, that it wasn't pneumonia and it wasn't the flu. It was just, something that they couldn't figure out at the time. But nonetheless, they had it for a good 5-6 days. So these people who are sick, this is easy. They're to stay at home until they are fever-free without the use of fever-reducing medicines for 72 hours. And their symptoms have improved for at least 72 hours. And then 7 days have elapsed since the onset. These are the CDC guidelines, and I encourage you to peruse the Center for Disease Control website. They have excellent guidelines, excellent information sections on their website. And it's one of the websites that we go to get our information. Next slide. Now, as HR individuals, what are some of the hard situations that we're seeing? Let's take example number 2. George, he's not sick, and he's been called back to work, but he is medically fragile due to underlying conditions: diabetes, obesity, smoking history, COPD. I've even seen one with rheumatoid arthritis. George requests to stay off work. I'm not ready to come back, HR. I'm fragile. I'm afraid to come into work. What do you do? Typically, we would look at this and say, well, are you sick? No, I'm just afraid to come into work. This is a really complicated issue. Then he submits this note from the doctor. It says, patient has a medical condition that places him at high risk for poor outcome of COVID-19. Look how the medical doctors are phrasing that. They're not saying he's sick right now, but he's saying that George has a medical condition making him high risk, that if he gets sick in the future, he'll have a poor outcome. This really I had to think through this one. We'll need to restrict exposure. So as attorneys advising HR, what do we say? Next slide, please. Of course, you've heard this from your counsel. Well, let's go through the interactive process. And so what can we ask the employee? Well, we can ask the employee and request medical documentation. George, can you give us a note explaining what your medical condition is? And then you can ask, George, does your medical condition require an accommodation? If so, what are you thinking? Next slide, please. Some other interactive questions. What is the disability? What limitations do you have? How will your requested accommodation, George, effectively address your limitation? Can we do something else? Will another accommodation effectively address your concerns? How will your suggested accommodation enable the employee to perform the essential job duties? Next slide, please. Now, you don't have to accept George's requested accommodation. Well, you can come up with your own suggested accommodation. But the point is, you want to go interact with George and ask these questions, maybe some more, and flesh out exactly what his condition is and how can you help him get back to work so that he can do his job. The CDC recommends having flexible leave policies. So as part of this COVID-19, HR should be, or we're recommending that you revise your leave policies, update them, provide for remote work allowances. Interact with George, like I said. And now you, as part of that interaction, you can say, George, I understand you're not sick, you're not disabled, you're just afraid of getting sick in the future. So here's an opportunity for us to explain everything that we've done so far. We've disinfected, we have workplace distancing, PPE, whatever you have done, this is a chance to tout all the things that you've done so far. Please, next slide. The bottom line is, with George, who's medically fragile in a high-risk category, we recommend allow him to telework, allow him to take an unpaid leave, allow him to take any accrued PTO, and if you have less than 500 employees, then he is eligible for that 80 hours of paid sick leave under the Federal Emergency Paid Sick Leave Act. You cannot dictate to George what he is to take, but you can make him aware that he has accrued paid leave, vacation or sick time. He has this extra bank of 80 hours. He can work from home if you allow that. But he is not going to be entitled to unemployment benefits or short-term disability if he doesn't want to do any of those things. Oh, I don't want to telework. I don't want to take my vacation time, and I don't want to use up this 80 hours of paid sick leave. You just have to let me stay off work and pay me. As HR, no, you don't. you can either have them come into work or have them take one of these paid leave or unpaid leaves. Otherwise, he's not going to be eligible for unemployment or short-term disability from your third party because he's not presently sick or disabled. Next slide.
John, let me jump in for a second, if I could.
Yes, Jack.
On a couple things, I do want to caution folks, when you're interacting with the employee, if that employee has not told you that they have a disability, but they're simply saying that they have concerns and they have medical conditions, like this is example number 2, I would caution you not to ask if they have, do not ask if they have a disability, do not.
Jack, you're muted.
Can you hear me now?
Yes.
Okay. If you ask them if they have a disability or treat them as if they have a disability and they have not acknowledged that, then you are opening yourself up to discrimination if you don't accommodate that person because you've regarded them as being disabled. So when you get into these close call situations, be careful, and I think you want to confer with your regular legal counsel as to how to handle it. And the other thing I would point out on that up to 80 hours of paid sick leave under the federal statute, that is 80 hours that the federal government reimburses the employee with a tax credit. You, the employer, would advance the money, but you would be able to recover it in your tax return. So that's something to be aware of. That's in addition to their normal sick leave, and it gives you some latitude. It's essentially 2 weeks of paid time off. The key thing to be aware of, and it's shown on the slide right here at the bottom, this you'll note is different than the note that George's doctor presented, who said, you know, he has a fragile condition or he has a medical condition. The doctor really needs to say that the doctor believes that George, the employee, needs to isolate because of the COVID-19 risk. That's right out of the statute. That is one category that will trigger this 80 hours of paid sick leave entitlement. So the note has to be sufficiently detailed to cover that eventuality. Thanks, John.
Next slide. Now here's a third situation. Tim is called back to work. He is not symptomatic. He's not medically fragile or high risk due to underlying conditions. He still refuses to come to work. I'm afraid. How do I know it's safe? And here's another chance for you to tout all the proactive steps that you have taken. Tim, we take safety seriously. We're compliant with federal and state local health guidelines. There are no recognized safety or health hazards in our workplace. We have no reported COVID cases arising from work. In this situation, I think you can hold the line and say, Tim, we want you back at work. And if Tim doesn't, and he says, well, I'm not coming in, you're going to have to make a decision whether you just allow him on an unpaid leave or if you terminate him due to an absence program. The problem Tim is going to have is that he's not going to be eligible for unemployment because you called him back and you had work available. And he's not entitled to any paid leaves unless you want to let him take his vacation time to run it out. But this is an individual that you can legitimately hold the line and have him come back to work when you need him. This is the person who is not symptomatic, doesn't have a fever, is not medically fragile or high risk with any underlying conditions. Next slide, please. Work from home policies. All of us, if not a lot of us, have been working remotely. As HR, we recommend that you have a formal written policy outlining what your work remotely policy is. And you want to make sure your employees have all the proper tools and connection to do their job. If you have hourly employees working from home, as part of that written policy, I would emphasize and mandate that they keep time records, a daily diary of when they start work and when they stop work. As part of the Fair Labor Standards, it is the employer's duty to make sure that you have accurate time records for your hourly employees. And if the employees are working from home, and if you don't have a written policy that mandates the employees to keep track of their time, down the road, the employees will say, well, I actually worked more than 40 hours a week. I worked 60 or 80 hours a week for that employer, and they didn't pay me overtime, and now you have an overtime suit. And then in the litigation, the lawyers are going to say, well, do you have time records of when these people were working from home remotely? And you as the employer, you want to be in the position to say, yes, we have a written policy where they were required to write down their time, and ideally, here, Mr. Good, here's the written timesheets of this hourly employee where they self-reported the start and stop times that they worked. That's the best case scenario. If you have that written policy that mandates tracking your time, that provides you, the employer, an additional defense. So when you go to the judge, you can say, we had a policy that mandated the employee write down his time, and this employee didn't do it. That's an actual defense to an overtime claim. And has added significance now that we're working remotely. So update your remote work policies. And if you don't have one, I would write one. Next slide, please. What current lawsuits are we seeing? The lawsuits are being filed. We have seen, not every day, but every other day, we're getting a new COVID-19 employment wrongful termination lawsuit being filed. And here's a couple of examples. Stephanie Jones versus Eastern Airlines. Stephanie was a director of revenue for Eastern Airlines. In mid-March, she requested 2 hours a day to work a flexible schedule. She had a child home. She needed to be able to come in late or leave early for daycare reasons. She asked repeatedly if she could have this flex time, and on March 27th, Eastern Airlines said, you know what, we're terminating you. This is not a good fit. She filed suit in Pennsylvania Federal District Court. And the takeaway here is, one, plaintiffs' lawyers are not waiting. They are filing these suits within a week or two of the termination. And then the recoveries, what are the plaintiffs potentially seeking? They are seeking double damages and attorney's fees. Additionally, individual managers and supervisors are being sued in your individual capacity. Now, your employer usually picks up the defense, but still, it's scary having your name identified in a lawsuit as being individually liable. So take these situations seriously and think through them very carefully. Next slide, please. Another lawsuit that we saw is filed here in Cuyahoga County. Nadu was an event planner at a nursing home. She wasn't a doctor. She wasn't a nurse. She was just an administrative organizer. She asked to work from home remotely. They denied that. She asked to use accrued PTO. That was denied. She complained about the lack of social distancing at her workplace. They fired her. Within 2 weeks, Nadu had a well-known attorney filing a lawsuit that she was wrongfully terminated in violation of Ohio's public policy. Next slide. And then another Cuyahoga County lawsuit. Kopit worked at a nursing home. A family member, her husband, was immunocompromised and high risk. If she brought the COVID home from work, she was afraid her husband would get sick. She again requested work remotely. That was refused. So she felt she had no other choice but to resign her employment. That is called constructively discharged. You leave me no other option, but I have to resign. That's a forced resignation, a constructively forced resignation. She is suing for violation of Ohio public policy, which requires employers to provide a safe workplace. She seeks punitive damages, back pay, front pay, and attorney's fees. Next slide, please. So the best practices we are suggesting is identify one person at your employment in your HR department as the COVID-19 leave expert. Next, train your HR department. Train your HR department to recognize these situations. Then have one person, this could be the same person, or you could designate a communication person, but have one person interacting with the employee. You don't want the generalist talking to the employee, and then the manager talking to the husband of the employee, and then the director talking to the uncle of the employee. I would just have one person coordinating this, so you have your lines of communication straight. And lastly, document all your interactions, all your phone calls, all your letters, and that's going to provide you the defense when they say, well, what did you do to interact with this person? Well, I talked to him 5 times and I wrote for the medical records, and we then followed up with a couple letters, and here's all our documentation of our 25 conversations with this person. That's a beautiful defense. So document the file. Next slide, please. And
John, on this point that you're making, the designating a point person, one of the things that you need to be attuned to is with all these lawsuits that are coming out of the woodwork and the creative theory, you've got issues with the Americans with Disabilities Act, which requires the employer, if the person has a disability, you have to have the interactive process and accommodate them if it's reasonable. And that could mean, in fact, more than traditional leave time. So if somebody has a disability and they require a modified schedule or more leave, that could take them beyond the FMLA time. So there's a lot of overlapping of these statutes. And the other point that John was touching on is by having one person handling these issues, you want to make sure you have a uniform application of your policies, because if you aren't uniform and even-handed, you're opening yourself up to a Title VII discrimination claim of unequal or disparate treatment. So if you give one person an accommodation or flexibility and somebody else who's in a protected category doesn't get the fair treatment, you've opened yourself up to another type of lawsuit. So you've got to be really careful. And of course, if it isn't documented, it becomes your word against their word.
Next slide, please. Warren. Warren, you might be muted. There you go.
Okay. Oh, all right. Good. John, can you hear me?
Yes.
Okay. Well, the question is, what happens when your employees are coming in, when they're walking in the door? And there are, normally when employees are walking in the door, you cannot ask them questions about their health. You cannot test them, but these are extraordinary times. So 3 things that really stand out are, yes, testing of employees can be done, particularly taking temperatures. Asking about other COVID-19 systems is all right, and requiring COVID-19 testing is questionable, depends on the situation. And the next couple of slides are going to go into each of these in more detail. Can we have the next slide? All right. In other words, during normal times, you can't take an employee's temperature, but certainly that's the one objective test which you now can do. And the EEOC has changed its guidelines to say that temperatures can be taken. These do not have to be taken by a physician. If you have a nurse employee or a person who's certified as an EMT, those would be the natural people to have to be taking temperatures, but it doesn't necessarily have to be a person like this. It could be the receptionist. The materials I read suggested that whoever does take temperatures should be a volunteer. They should be given the appropriate PPE, and touchless thermometers are really what should be used. And someone asked the other day, what are you talking about? Well, you can get the touchless thermometers now at Walmart or Walmart Internet or Amazon for about $65, and they do work. My wife went to her dentist a few days ago, and the first thing she had to do was have her temperature taken by a touchless thermometer. Next slide. We're looking for temperatures over 100.4. That is considered having a fever. The results in light of the ADA and EEOC guidelines have to be kept confidential. This is not information that can be shared with other employees. Notations of tests can be made, but these cannot go into personnel files whatsoever. These and no medical information can ever go into personnel files. They have to go into another file for each employee. Question is, where do you take these? Well, they should be taken where the employee comes in. Next slide. Well, employees can also be asked questions. And it's the questions we've all become familiar with regard to COVID-19. Do you have a temperature? Do you have chills, fever, coughing, shortness of breath? Have you been around someone who has been diagnosed with COVID-19? Have you gone to a high-risk area? And I've listed a couple here on the slide. I would include, I say Eastern South Dakota, but the whole Sioux City, Iowa, Sioux Falls, South Dakota. I think I've gotten that straight, that whole area. Have they been to the Washington, D.C. area? Have they been to Boston? I would include those areas. Other inquiries can be made, but they have to be job related. If they're not job related, then you can run into some EEOC problems very quickly. Next slide. Can an employee be forced to have a medical exam? And this is that questionable area. Obviously, if they have some symptoms, some real symptoms like a fever, for instance, which is one of the only objective things we're talking about. In fact, it may be the only objective test that we're talking about. Yeah, you might require that person to have a negative test, negative COVID-19 test before they come back. If they've been living with someone who has tested positive, it might make a lot of sense to have them tested for COVID-19. Of course, the problem here is that while we're growing in the number of tests that can be given, it's still pretty difficult to get a COVID-19 test. So you got to really be careful. The employer really has to be careful concerning who is asked to have a COVID-19 test. Obviously, if it's a new employee, medical exams are all right after a conditional offer of employment. Our next speaker is going to be Jack Klosnick.
Okay, thanks, Warren.
And next slide.
Slide. Yeah, here we go. Go back to the previous slide. Thank you. Okay. So I'm not sure what slide we're up to now, but what we want to get to is what can offices require of visitors and employees? What are the limits? What is the recommended scope of the questions about health and wellness assessments? A standard set of questions should be prepared and directed to everyone by someone assigned to handle that task. And I'm suggesting that you want to have a checklist so that it's, as I said before, it's uniform application. And as John suggested, or Warren suggested, if you have somebody that's trained to do this and you give them the checklist, that's the way to ask these questions. And as Warren said, they need to be relevant. And what you're really doing here, why are you asking these questions? Obviously, it's to find out if the person's entering the place of business have exposure or have symptoms of COVID-19, and you want to protect yourself, your coworkers, your visitors from exposing them. That's the whole point of this. Next slide, please. So the suggested questions for the checklist: do you currently have symptoms? Warren touched on that, of COVID-19, and the symptoms that we've been seeing keep growing by day as we become more knowledgeable of what the symptoms are. So in addition to the fever, chills, cough, a sore throat, shortness of breath, recent loss of taste or smell, and just in the past few days, I've been hearing about COVID toes, COVID fingers, which are blotches, red blotches on your, primarily on the toes, and of course, fatigue. So there may be new symptoms that are documented that will show you an indication that the person may be COVID positive. And of course, Warren talked about, have you been exposed to someone in your household that's been diagnosed? Have you had contact with a COVID positive person in the past 14 days? And Warren's talking about having someone at the entryway administer the temperature. That's perfect, that's great. But I would suggest to you, a lot of places are having employees take their temperature at home before they come to work. And if you have this checklist, they would be certifying that they took their temperature and it is below 100.4. Now, the problem with that is you don't have an objective measure. You're taking the employee at their word. You're also doing that if you ask the visitor as well. But I think that is acceptable because it's not always realistic or practical to have someone taking the temperature for the person. And as Warren said, until we get reliable tests available, it's probably not feasible to be administering tests. And I think in the ideal world, along with what John said, with the checklist, it would be certainly nice to have the visitor or the employee initial the checklist to say that they have acknowledged that they don't have any symptoms. And that is part of the documentation that if you are hit with a lawsuit, you've got the documentation. But I will tell you that those questions are confidential. The answers to those questions will be confidential. So you don't want those floating around and you don't want to share those with other employees. Next slide, please. As I was just mentioning, all medical information, including temperatures, are confidential under HIPAA. It's private information. Obviously, on item 4 on this slide, if an employee or a visitor provides objective evidence in response to the questions or the temperature that they are COVID positive or been exposed, of course you want to send them home. You want to isolate. You want to notify people that have been exposed to or potentially exposed to someone who's COVID positive that they have been exposed or may have been exposed, and to take precautions, but you do not want to say or identify who the person is that exposed them. That's the confidential information that should not be disclosed. Of course, then you want to thoroughly clean the area and disinfect the area where the COVID positive person entered the workplace. Item D is really kind of interesting. We've been saying confidential, but you'll see you are obligated to notify the local health department of all suspected cases of exposure. And that would mean identifying the people that have been exposed and identifying the person who is COVID positive, and that's for contact tracing. So that's the only exception to the confidentiality. You can notify, not only can you, but you're required to notify the local health district or health department.
Jack, before you go on, there's a question here.
Okay.
If you have that kind of checklist that you want employees to initial and an employee refuses to do so, what action should you take?
Well, John, jump in if you disagree, but I think if they don't complete, it's a work rule, in my opinion, and and the EEOC has acknowledged and recognized that it's such a serious concern that employers and businesses are allowed to ask questions they were not normally or previously allowed to ask, because this is in fact a pandemic. So I would say if the employee or visitor refuses to comply, then you should not let them enter. That would be my response. Warren, I don't know if you have any thoughts.
I agree.
I will tell you that on this notification, point D, the health district, OSHA has just released a guidance that increases the responsibility of even small employers to record work-related illnesses, specifically a COVID-19 would be if it's work-related. Now, you have to make a reasonable effort to find out if it's work-related, because somebody could be COVID positive and it's not because they became COVID positive in the workplace. So that's the area where did they become exposed in the workplace, or is it something from outside? But my point would be, if you're in that situation, be aware to check the OSHA guidelines, because there is a requirement to record work-related illnesses or injuries. And this would qualify if the exposure was in the workplace, caused by the workplace, a workplace-related illness or injury, and it's called an OSHA 300 log sheet. It's not necessarily reported, it's recorded. So you have a record. It's part of the documentation that John's talking about. Let's go to the next slide. All right, precautions for employees in the workplace. Now, these are from guidances from the state of Ohio, which are a lot of them are being relaxed as recently as this week, but these still remain in effect. Employees must wear face masks at work unless they are sitting alone, this is in an office setting, in an enclosed workspace, not merely a cubicle. That was what the guidance was back in April. They had to, if you're not in an enclosed workplace, you need to wear a mask. If you're working in a cubicle, you would have to wear a mask. That was relaxed on May 1 to, if you're working in an assigned work area and you're not near other people, like 6 feet social distancing, then you don't have to wear a mask for exposing other people. But there are exceptions for employees having to wear a mask. Health reasons, obviously, if the employee has breathing problems, if safety reasons interfere with wearing a mask, if there's other practical reasons, those can be taken into account. And of course, if the employee has a disability that precludes them from wearing a mask, there are exceptions. So a lot of this is common sense. It's one thing to dictate these things, there's another thing to apply them in reality. Let's go to the next slide. Precautions, more precautions. Face masks are recommended but not mandatory for visitors or customers. And of course, you'll see this like in grocery stores. a lot of grocery stores are requiring visitors and customers to wear masks. Governor DeWine has left that up to the discretion of the business. So you need to be thinking in terms of protecting your employees, protecting your coworkers, protecting your customers and visitors. So it is your authority to require visitors or customers to wear masks if you think it's appropriate. It's suggested if you have access to the masks, to make them available to visitors and employees coming into the workplace. And of course, you want to enforce the 6-foot physical distancing, and you want to have signage up. Now let's go to the next slide. More precautions. These are still in effect under the state of Ohio. Minimize face-to-face contact between employees, customers, and visitors, and to the extent possible, like we're doing today, substitute virtual or remote communications. I already talked about posting signage, and hand washing is another one, about as well as distancing. And of course, providing hand sanitizer and disinfectant to clean work areas. And I want to emphasize what John said earlier. It's crucial. It's not unlike we're all familiar with sexual harassment policies and procedures, and the importance of not only having the procedure, but training people about what the procedures and the policies are, and reinforcing those policies and procedures periodically. The same would apply here. It's not enough to have these policies and procedures in place if people don't know about them. Next slide, please. So returning to work for COVID-19 following exposure, you can and should require a test to prove that they are not COVID positive, and you can and should require certification, a note from a medical professional to say that, in fact, that person is safe to return. Once again, this information is confidential, and it has to be kept confidential. And if we go to the next slide, to put the exclamation point on this, if it's a coworker that's coming back, unlike the old TV show The Office, don't do something crazy like a big banner, "Welcome back from COVID-19" with balloons and celebration. That's the employee's medical information. And until we know more about, well, it's their private information anyway. And I think we're still trying to find out what's the long-term effect of having exposure to this COVID-19. So respect the privacy. You can welcome the employee back, but do not get into details about their medical condition. And once again, as I mentioned before, you are required to notify the local health department of a visitor or an employee who is suspected to have been COVID positive. And we already talked about the OSHA recording. With that, I'm going to pass it back to John.
Next slide. What steps should employers take to reduce risk of exposure? Exposure from OSHA knocking on your door and citing you thousands of dollars for not having the proper documentation. At this point, I suggest the HR departments think about putting together an infectious disease preparedness and response plan. You may have an influenza response plan, but I'm suggesting, and OSHA is also saying that having an influenza response plan is not the same as having a COVID-19 response plan or a pandemic preparedness and response plan. So let's prepare another plan to address COVID-19. You could call it an infectious disease pandemic preparedness and response plan. But let's take everything that we've learned these past 6 weeks and reduce it into a document saying that this is our action plan for a pandemic, including COVID. So the purpose of that is when OSHA knocks on your door, they're going to want to see all the traditional stuff, but then they're going to say, where's your infectious disease preparedness plan? And I don't know how many of my clients would be able to produce one. So this was a little bit of an eye-opener. So that's why I highlighted here. As part of that plan, outline your basic infection prevention measures. include a page on your how you identify and isolate sick employees. What is your communication plan? And just summarize your workplace controls that you've put in. Engineering controls, administrative controls, your work practices, any PPE requirements. So you've probably done all this work already. And all I'm saying is collate it into a 5-page, a 10-page document and call it your infectious disease preparedness response plan. So in case OSHA comes to inspect your workplace and they ask for it, you have it. Next slide, please. What is, when OSHA comes and knocks on your door? You know, the employers are saying, well, what if we don't have anything, but we acted in good faith? How far will the good faith defense get you? And from OSHA's perspective, they're going to look at, okay, let's explore this good faith. Have you, the employer, explored all options to comply with the your OSHA requirements? Have you done any virtual trainings during this time period? Have you reduced or writing your remote communication strategies? Have you implemented any interim alternative protections? Have you rescheduled any required annual audits or activities as soon as possible? So if you can say, yes, we've rescheduled, we weren't able to do this because we shut down, but now we're doing this audit, we did this audit as soon as we could, that's a good faith effort. Next slide. Here's a couple of the websites that Warren, Jack, and myself used to gather all this information. And I think you'll find these helpful as well. Next slide. And this is the responsible restart guidelines from the state of Ohio for general office environments. And this is very helpful. Next slide. And here's our contact information if anybody has any questions. So we have a few minutes, so if you want to submit any questions to the chat box, we'll gladly respond. And thank you for having us today.
This is Jack again. I encourage you to take a look at the page, the slide with the websites that we've used as resources because they are really helpful. And I particularly recommend the Department of Labor website that has 93 questions and answers with fact patterns. So it's helpful to look at that because it covers a boatload of situations that you might encounter with these leave issues and how to handle these situations where employees want to use leave. So the Department of Labor website, Wage and Hour Division, we gave you the correct information to punch in for a Google search and it'll take you there. Look for their 93 Q&As and that may increase. I mean, they keep on supplementing. The EEOC website, similarly, we gave you the specific one. The abbreviation there is WYSK is what you should know. That's their acronym for what that particular publication is. So that is regularly updated as well. And that's a series of questions and answers where the EEOC has taken fact patterns and given their opinion as to how it should be handled. So do use the websites because these 1-hour presentations can be fast information overload, and these websites are very informative and they change from day to day. They just keep adding as we find out more information. Thank you.
And Rick, we'll turn this back over to you.
Great, thank you guys. Just wondering if there are any questions at all. I don't see anything in the chat box right now. I guess we're good. So just want to thank everyone for joining us on the call today. Thanks again to John Good, Jack Klugsnick, and Warren Rossman of Weston Hurd for their excellent presentation today. There's a lot of valuable information here. We encourage all of you to share with us your thoughts on topics you'd like to see covered in future calls, and we'll do our best to address those for you. And please stay tuned to your emails as we announce our next call. And if there's any other manufacturers in your network you think would benefit from this information, please feel free to share this with them or let us know, and we'd be happy to reach out to them. As I mentioned earlier, this call has been recorded, and an archived version will be available on our YouTube channel and in the COVID-19 resources section of our website. Thanks again. Be safe, stay healthy, and we look forward to seeing you all again soon. Thank you.